Good morning. This is John Neerman, and it's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, July 1st, 2020. The time is 9:30 a.m., and I'll begin with a roll call. Commissioner Lindley, are you there?
I'm here.
Good morning.
Good morning.
And Commissioner Janek, are you there?
Present and accounted for.
Good morning. So our commissioners are all present. How about our General Counsel, Ms. Smith? Are you on the phone?
I am. Good morning.
And good morning. And our Public Interest Counsel. Vic, are you there?
Did you hear me, sir? I'm here.
I hear you now. Thanks, Vic. Good morning.
Okay. Morning.
I'd like to remind folks to keep their phones on mute when they are not speaking. I'd also like to remind anyone who is here only to listen that they can also watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will let the speakers know their time limits. Registration closed at 9:30, but if you would like to address the commission on a particular item, please email agenda@tceq.texas.gov and provide your name, your affiliation, and the item that you'd like to comment on, and we'll do our best to accommodate the request. For those of you who are making presentations, please wait to begin your presentation until either I or our General Counsel have asked you to begin speaking. And also, please double check your microphone to make sure it's turned back on. And with that, I'd like to thank everybody for being present. And Ms. Smith, I'll have you call the first item in just a moment, but we're coming up on our 4th of July holiday here. I just wanted to take the opportunity to remind everybody that the novel coronavirus that we're dealing with is not taking a holiday. So please be safe, take care of yourselves, take care of your families and each other. Wear face masks, social distance, stay home to the extent possible, and be well. So Ms. Smith, if you would, please call the first item.
Item number 1 is the application by Cherryville GP Incorporated and Cherryville Number 5 Limited for new Texas Pollutant Discharge Elimination System permit number WQ00157380001. The parties have been notified that the commissioners will not take oral argument but may ask questions. We have some people registered for this item, and their presence will be noted for the record.
Thank you, Ms. Smith. And for the benefit of those who are unfamiliar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And then, assuming that at least one requester has met those requirements, then we consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Associations can have standing if they name at least one member who would have standing in his or her own right and also raise issues that are both germane to the organization's purpose and relevant to this application. So colleagues, on this item, we have numerous hearing requests. There are just a few, in my mind, that satisfy both the procedural and substantive requirements to be granted a contested case hearing. I'm going to recommend that we grant the request of Ben O. Corp, Michael and Nancy Ohlendorf, the San Marcos River Foundation, and the Texas Rivers Protection Association. I would deny the rest. The remaining requesters fail to identify a personal justiciable issue, or in the case of the associations, fail to identify a member that has a personal justiciable issue. And most of the requests fail because the requester's property is located too far from the facility and from the outfall to implicate an interest that is different from the general public, or the requester failed to state how they would be personally affected And in addition, several failed to identify their property locations. So colleagues, let me pause there and gather your views on who's entitled to a hearing. And Commissioner Lindley, let's begin with you. What are your thoughts?
I came down on those same, I guess, 4 parties, the 2 associations, Benno Corp, and the Ohlendorfs.
Great. Commissioner Ginecca, how about you?
Likewise, that aligns with my conclusions as well.
Good. Well, let's turn to the issues then. And again, for the benefit of those who are not familiar with our process, we refer issues of fact that have been timely raised by an affected person and that are relevant and material to the application. Stated differently, the issues have to be within our jurisdiction on this type of application. So, for example, on a wastewater discharge application, we can't consider economic impacts, such as impacts to property values, flooding, or whether reuse of waters is required. And colleagues, I would organize the request into 8 referable issues, and let me just read through them. First is whether the draft permit is protective of water quality and the uses of the receiving waters, consistent with our Texas surface water quality standards, including the protection of the requester's use and enjoyment of their property. Second issue is whether the draft permit is protective of the uses, specifically of Dickerson Creek and the San Marcos River, including as a source of groundwater for public and private supply, for aquatic life use, and for primary contact recreation use. The third issue is whether the draft permit complies with applicable nuisance odor requirements. Next, whether the proposed discharge complies with the applicable anti-degradation requirements. Next, whether the application properly describes the discharge route. Whether the applicant sufficiently demonstrated need for the volume requested, as need is understood under section 26.0282 of the Water Code. There's an issue about whether notice was adequate, and finally, whether the draft permit contains adequate requirements, including operational requirements to protect water quality. And that's how I would organize the issues. Commissioner Lindley, how does that sound?
Those 8 issues are on point with what I agree with you. Let's leave it at that.
Okay. Commissioner Ginecca?
Yes, likewise, I'm also landing on those 8 issues, and I think I would be ready to move on as well.
Great. All right. Well, in addition to our parties and our issues, there were some requests for reconsideration. In my view, they don't raise any issues that were not already addressed in the response to comments, so I would propose that we deny those. Since we have a limited number of parties that we're referring over, I think it could be useful to refer this to the alternative dispute resolution group and see if we can't negotiate a settlement here. And then, given the scope of this hearing, and obviously we're in the middle of a pandemic response, so I would allow the full 180 days for a hearing. So I'm happy at this point to entertain any additional thoughts or comment, or entertain a motion.
I'm in agreement with everything you said, and I have a motion. If y'all are ready, I will
Proceed.
Rattle it
Yes.
off.
Yeah, go ahead.
I move that we grant the hearing request filed by Benno Corp., Michael and Nancy Ohlendorf, the San Marcos River Foundation, and the Texas Rivers Protection Association, that we deny all remaining hearing requests and requests for consideration, that we refer the matter to TCEQ's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts. We refer the application to SOA for a contested case hearing concerning the following issues. A, whether the draft permit is protective of water quality and the existing uses of the receiving waters in accordance with applicable Texas surface water quality standards, including protection of the requester's use and enjoyment of their property. B, whether the draft permit adequately addresses nuisance odor in accordance with 30 TAC 309.13. C, whether the proposed discharge complies with applicable anti-degradation requirements. Excuse me. D, whether the draft permit is protective of existing uses of Dickerson Creek and the San Marcos River, including A, use as a source of groundwater recharge for public water supply and private wells, B, aquatic life use, and C, primary contact recreation use. E, whether the application properly describes the discharge route. F, whether the application sufficiently demonstrated need for the volume requested in its application for a new discharge permit under Texas Water Code 26.0282. G, whether the applicant substantially complied with applicable notice requirements, and H, whether the draft permit contains sufficient provisions to ensure protection of water quality, including necessary operational requirements, and that we set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
And I would second that motion. I think there was a little transposing of the word applicant and application, but I think it still captured the meaning accurately. You might just,
yeah.
There you go. You might just repeat F, issue F.
Happy to do that. Issue F that I want in my motion is whether the applicant sufficiently demonstrated need for the volume requested in its application for a new discharge permit under Texas Water Code 26.0282.
I would second that motion.
Okay, recognizing the clarification offered, the motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion passes. Ms. Smith, please call the next item.
Item number 2 is an application by Clean Harbors San Leon Incorporated for a major amendment of Texas Pollutant Discharge Elimination System permit number WQ004-080086000. The parties have been notified that the commissioners will not take oral arguments but may ask questions. Those who have registered for the item will be noted for the record.
Thank you. And again, on requests for contested cases, we begin with the question of whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And here we have a single requester who expressed concerns about the discharge without saying what those concerns are. And if we were to grant the request, the commission would have to articulate the personal justiciable issue for the requester. And that kind of speculation is just not workable. So I would deny the request and grant the amendment. Commissioner Lindley, what are your thoughts on this?
I'm in agreement. I don't think the requester's comments provided enough information to grant a hearing.
Thank you. Commissioner Ginecka, I'll invite your thoughts or a motion, or both.
I landed right in the same place each of you did, and I will proceed with the motion. I will move that we deny all hearing requests, grant the major amendment to Clean Harbors San Leon Incorporated for TPDS permit number WQ00040860000 as recommended in the draft permit prepared by the executive director, and adopt the ED's response to comments.
I second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecka?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is consideration of whether to affirm, modify, or set aside the emergency order appointing a temporary manager for the public water system owned and operated by Beachview Acres Water Association. The ED should speak first as the movant, followed by the respondent, if present. Hearing requesters, presently there are none. Mr. Tommy Bradley of Hilco Services Incorporated, if present, and then OPIC. And OGC recommends a 5-minute time limit on each party's presentation. The Executive Director's staff is here to begin and present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Jaime Garcia, and I am an attorney with the Litigation Division here representing the Executive Director. And also here today is Ben Worms, also with the Litigation Division, Nima Montahan of the Water Supply Division, and Caitlin Maringer of the Waco Regional Office. This item is the emergency order appointing a temporary manager of the public water utility owned and operated by Beachview Acres Water Association. The circumstances that led to the issuance of this emergency order are as follows. On June 10th, 2019, a TCEQ investigator contacted Ms. Ann Robinson, the utility's administrative contact, to schedule a comprehensive compliance investigation. Ms. Robinson stated she would be moving away from the community and would no longer be responsible for the system. And the investigator made several unsuccessful attempts to contact Ms. Robinson to finally schedule a date for the CCI. Ms. Robinson was not on site to assist the investigator during the July 11th, 2019 investigation. And during this investigation, the investigator documented free chlorine residuals well below the mandated level of 0.2 milligrams per liter. And the investigator also noted empty chlorine barrels at the utility, poorly maintained equipment, including the ground storage tank, service pump, and distribution tank. On April 28, 2020, TCEQ Waco Regional Office received complaints of a water outage at Beachview Acres, which were the result of a failing service pump. On May 1st, 2020, an investigator with TCEQ contacted Ms. Robinson to schedule an investigation as a result of the outage, and Ms. Robinson refused to participate in the investigation and could not provide information for an alternate administrative contact. On May 5th, 2020, the investigator conducted an on-site investigation and noted the service pump was poorly maintained and ran continuously, increasing the likelihood of another outage. On May 8th, 2020, the utility experienced another outage, and as a result, the Waco Regional Office Water Section Manager contacted Ms. Robinson, asking her to issue a boil water notice. Ms. Robinson refused to issue a boil water notice and again could not provide contact information for an alternate representative of the utility. This utility has been abandoned due to the failure to properly maintain equipment, failure to provide adequate water treatment, failure to notify customers of potential health hazards, and for demonstrating a pattern of failing to respond to the TCEQ. Because of this, on June 1st, 2020, the executive director issued an emergency order appointing Hilco United Services Incorporated as temporary manager for the utility. Hilco is a utility cooperative which provides electric service to the Beachview Acres utility and customers of Beachview Acres. And additionally, Hilco provides water service in the area and maintains an emergency contact with the Beachview Acres system. Hilco's expertise, combined with their existing relationship with the Beachview Acres customers, has made them a willing and capable temporary manager. The water utility is currently providing continuous and adequate service to customers, and we have received no complaints regarding outages or the quality of water service. The executive director respectfully requests you affirm the June 1st, 2020 emergency order. And we are now available to answer any questions you may have.
Thank you, Mr. Garcia. Well presented. I have none. Commissioner Lindley, any questions?
No questions. Thank you, and everyone else who's worked on this issue.
Thank you. Commissioner Janeka?
No questions either specifically for ED staff at this time. Appreciate that.
Thank you. Is there anyone representing Beachview Acres Water Association on the line? All right, hearing none. And Ms. Smith, I understand there are no hearing requesters. Is that correct?
Sorry,
Ms.
it took
Smith,
me
I
a
can't
second to
hear
get.
Sure.
Sorry, it took me a second to get unmuted. That is correct.
Okay. And is Mr. Bradley or anyone else from Hilco United Services on the line? Okay, hearing none. Office of Public Interest Counsel.
Good morning, Vic McWhorter, Public Interest Counsel. OPIC recommends the Commission affirm the emergency order issued June 1st, 2020, appointing Hilco United Services, Inc. as temporary manager of the retail public utility owned by Beachwood Acres Water Association. We'd also like to acknowledge Hilco for stepping forward to help these customers have improved service.
Thank you for that, Mr. McWhorter. I want to give Beachview Acres Water Association one more opportunity if they happen to be on the line or listening. I suspect that's not the case. Okay, hearing none. And Mr. McWhorter, I'm sorry. Had you finished your presentation? I didn't cut you off, did I?
No, you didn't. I did finish. Thank you.
Okay, thank you. Well, let me add my thanks too to Mr. Bradley and Hilco United Services for taking on this assignment and for maintaining the water supply while we seek a receiver for this system. And colleagues, this is a pretty clear case of abandonment. I think we should affirm the executive director's order. I would offer one clarifying edit, however, to finding of fact, paragraph 17. So let me lay out the motion with that edit, and then we can discuss it. So I move that we affirm the executive director's June 1st, 2020 emergency order appointing Hilco United Services Incorporated as temporary manager for the water utility owned and operated by Beachview Acres Water Association with the following modification. Modify finding of fact paragraph 17 subclause 1 to state, quote, 1, failed to provide appropriate water treatment resulting in potential health hazards, end quote. And I further move that we issue an order approving and modifying the executive director's emergency order to reflect this change. And that ends my motion. And Commissioner Lindley, let me begin with you. How does that all sound to you?
I would second the motion. That sounds good to me.
The motion has been made and seconded. Commissioner Ginecca, do you have any additional comments or thoughts before we proceed to a vote?
No particular questions at this point. I'm certainly strongly in agreement. I think this is a very clear case of abandonment, and it immediately raised issues or questions in my mind about whether there was any legal duty that's been abandoned where there should be actions taken at a local enforcement level. But I'm confident that our agency is well equipped to handle the process moving forward.
Appreciate that. Again, the motion was made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecca?
Aye.
I also vote aye. The motion is unanimous. Ms. Smith, please call the next items.
That brings us to our enforcement docket, which is items 4 through 35. Before we begin, Commissioner Lindley would like to speak. Commissioner Lindley?
Yes, thank you. I am going to recuse myself from item 35. Due to my involvement on that issue when I was in the ED's office, I think out of an abundance of caution, I need to not vote on that. So with that, I'm happy to discuss items 4 through 34 and then let you gentlemen take up 35 if that works for you all.
Yeah, that's great. I appreciate that. Thank you. So I guess the executive director is up now.
That's correct, and they're here to present their items.
Good morning.
Good morning. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division representing the Executive Director. Pending before you are items 4 through 35. The total assessed administrative penalties are $1,294,992, with $203,153 deferred, $488,677 applied towards supplemental environmental projects, and $603,162 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley, any questions on the docket excluding item 35? And Commissioner Lindley, you might check your line to see if it's muted.
Whoop, I think I was muted. I didn't even know I did that. Thank you. I did have a question on item 13. I guess I just want to kind of hear from the ED, just talk it through probably more than anything else about, I guess why it took so long to get the NOE out and kind of better understand why a corrective action plan that, you know, people, at least my understanding, pretty much always have to come up with, why that from what I can tell, is what got them the good faith effort reduction. And I think that's all the questions I have on it. And hopefully that makes sense.
Commissioner Lindley, this is Brian Sinclair for the Executive Director. Will have to look into the reasons for the delay on the referral. I am not. I did not look into that. I do know that the good faith effort to comply is as a result of them completing their corrective action plan prior to the notice of enforcement. So they did get the good faith effort
Okay.
to comply on that.
Okay. Why don't we just, we don't need to talk about it anymore here today, but I don't know the best avenue. I guess we can talk about it in the future, kind of the timing of it.
Yeah, Commissioner Lindley, I think there's really kind of two paths we could take here. We could, if you have, some strong concerns specific to this item, we could continue this item and allow time for you to do some additional investigation and discovery on it. Or we could, if your concerns are more general in nature about the process and just making sure that our process going forward is in line, we could move forward with this order today, and you could do those kind of more general prospective investigations yourself. So
Sure. Yeah. Option B. I'll call it option
Okay.
B. It's fine.
Okay.
I'm fine with what's assessed. I mean, I do think all of that's appropriate. So I will support a motion to adopt that today. That's not really a concern, and then can have other discussions more general in nature later down the line.
Okay, appreciate that. Yeah, no
Thank
question.
you.
It's a significant violation and a significant penalty, but I appreciate that. Do you have, Commissioner Lindley, any other questions for staff on that docket?
No, sir. Thank you. I'm good.
Okay. Commissioner Janeka, do you have any thoughts on the docket?
No, I appreciate Commissioner Lindley's question, or the two questions you wanted to get at, and I share that concern from a general process perspective. So if possible, Mr. Sinclair, if there is any discussion that you intend to have with Commissioner Lindley's office following this, or any briefing, one pages or anything, walking through the timeline on this item, I would love to participate in that discussion separately, just in the general nature, looking at those processes so that I can help better understand it. But I'm comfortable with this docket of items before us and ready to proceed.
Okay.
Thank you, Commissioner Janeka. Thank you, Mr. Sinclair. Ms. Smith, are there any interested persons who have signed in to speak?
Yes, on items 35 and 13, we had individuals who had signed in and indicated that they don't wish to speak unless the commission had questions. So
Okay.
they're just here, but their presence will be noted for the record.
Okay, I appreciate that. We'll turn to you, Mr. McWhirter.
My office reviewed these items, and we recommend approval of the proposed orders.
Thank you. Appreciate that. I agree. I've reviewed these items. I will note that item 35 is back after a remand. Certainly our initial swipe at this, I think a couple of years ago, did not put us in an appropriate place with respect to the gravity of the violation and the amount of the penalty. I think we've done better this time around. There were no comments on this settlement. So I agree that we should move forward with this item and with the rest of the docket. Commissioner Lindley, did you have any additional thoughts?
I do not. I'm fine with items. The ones I'll be voting on 4 through 34 as recommended today. So I can make a motion on just those items and then let you all take up item 35 or
Sure.
whatever
Yeah.
is most appropriate.
Yeah,
Okay.
that'll work. Commissioner Janeka, you don't have any additional comments or thoughts at this point?
Thank you. None. Ready to move forward. Thanks.
Okay. Yeah. Go
Then
ahead.
I will move that we adopt items 4 through 34 as recommended today by the Executive Director.
I second that.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. That motion carries, which leaves for the two of us, Commissioner Janeka, item 35. And do you want to offer a motion on that?
I certainly do. It sounds like you're comfortable with it, and I've reviewed some of the record or the history on this item, and I certainly have the same thoughts as you do. Having not had the benefit of looking at it the first time in this seat, I appreciate your thoughts, Chairman. So I would move that we adopt item 35 as recommended today by the Executive Director.
Thank you. The motion's been made. I second it. Commissioner Janeka, how do you vote?
Aye.
I also vote aye. That motion on item 35 carries as well. Ms. Smith, when you're ready, I'll ask you to call the next item.
Item 36 is consideration of the adoption of new, amended, and repealed sections of 30 Texas Administrative Code, Chapter 344, regarding landscape irrigation. The Executive Director's staff is here to present this item.
Good morning. And you might double check your phone just to make sure that you're unmuted.
Okay. Yes. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Marilyn Gates with the Program Support and Environmental Assistance Division. With me is Alicia Ramirez with the Environmental Law Division and Christy Mills-Jurog, also with the Program Support and Environmental Assistance Division. The adopted rulemaking incorporates some of the requested changes made by the Texas Commission on Environmental Quality Irrigation Advisory Council in 2 rule petitions, non-rule project numbers 2017-041-PET-NR and 2017-042-PET-NR, as well as amends existing sections, repeals a section, and adds a new section in order to better align the rules with the state statutes and other related regulations. These adopted revisions will strengthen the rules by increasing protection of public health and water conservation. The proposed rules were published in the January 31st, 2020 issue of the Texas Register. A public hearing was held on February 27th, 2020. The public comment period closed on March 3rd, 2020. The rule team did receive public comments, and based on those comments, the rule team made the following substantive change. A change was made to the definition of irrigation system in Chapter 344-121 to include sprinklers and sprinkler systems. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapter 344. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Gates. I have none. Commissioner Lindley, any questions?
I have no questions. I would just say that I appreciate the substantial stakeholder involvement on this one. It's been a long process, and I know there are a lot of people that had a lot of thoughts on it, and always appreciate when we're able to hear from the stakeholders and appreciate their engagement on the topic.
Thank you for that. Commissioner Janeka.
Just echoing my colleagues' comments there, I think this was a long effort. Commend all the stakeholders in our ED staff for running that marathon, and no questions further at this time.
Thank you. Ms. Smith, is there anyone signed in to speak on this item?
No one is registered to address the Commission on this one.
Thank you. And Mr. McWhorter, what are the Public Interest Council's thoughts on this?
OPIC agrees with the ED that the rulemaking will protect public health and promote water conservation. We recommend adoption of the proposed changes to the Chapter 344 rules as presented by the Executive Director.
Thank you. I appreciate that. I want to begin by thanking TCEQ's Irrigation Advisory Council for its petitions, which were the impetus for this rulemaking. This is one of those deals where we had stakeholders who had very differing opinions on this, and we couldn't land on all of them simultaneously, but I think we've landed in a good place. Importantly, the rule removes atmospheric vacuum breakers as an approved assembly and now requires testing of backflow prevention assemblies when they're installed, repaired, replaced, or relocated, as well as making other clarifying changes to definitions, as we heard about just a moment ago. What we stopped short of doing is designating all irrigation systems as health hazards or requiring periodic testing of all assemblies, but only to maintain those designations and requirements as they exist under the existing rules, pre-existing or current rules. There was a recommendation in the petition. Although we had those recommendations in the petition, staff ultimately concluded that there was not enough information connecting backflow prevention assemblies to health effects on a scale that would justify a significant increase in the burden to homeowners. Just a personal observation, testing is a good practice. That we're not requiring it in this rulemaking doesn't mean that local governments can't impose additional requirements, and also individuals can make their own choices about this. So with all that said, colleagues, I think it's appropriate to move forward with this rulemaking, and Commissioner Lindley, I'm happy to entertain any additional thoughts or a motion.
I have no additional thoughts. I think you covered everything well. And so I would move that we adopt the new, amended, and repealed sections of 30 Texas Administrative Code, Chapter 344, as recommended by the Executive Director.
Thank you, Commissioner Janicka. Any additional thoughts or a second on that motion?
No other thoughts, but a resounding second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janicka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 37 is consideration of the adoption of an amendment to Section 336.1310 of 30 Texas Administrative Code, Chapter 336, regarding radioactive substance rules. The Executive Director's staff is here to present this item. Before you begin speaking, please state your name for the record. Thank you.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Ashley Forbes with the Radioactive Materials Division. With me is Amy Robinson with the Environmental Law Division. This rulemaking amends Chapter 336 to adjust the Curie inventory charge. The proposed rules were published for comment in the May 8, 2020 issue of the Texas Register. The comment period closed on June 9, 2020. No comments were received during the comment period. On June 26, 2020, the Texas Radiation Advisory Board voted to support the rulemaking as proposed. No changes have been made since proposal. Staff requests approval for the adoption of amendments to Chapter 336 and permission to make non-substantive corrections to the adoption package if necessary to comply with Texas Register format and style requirements. Thank you for your consideration, and we're available to answer questions.
Thank you. And I do have just a few. Does this rulemaking affect at all the types of waste allowed to this facility? Does it allow any new types or different types of waste into the facility?
And no, Chairman, Mayor Ehrman, this does not affect the types of waste. This is the same. This site accepts low-level radioactive waste.
And does anything in this rulemaking affect the volume of waste authorized to be placed at this facility?
No, it does not affect the authorization for the volume of waste at this facility.
Okay, so this rulemaking is solely about a change in the rate structure for the same kinds of waste that the facility is already accepting.
That is correct, Chairman.
Okay, I appreciate that clarification. Commissioner Lindley, do you have any questions for staff?
No, you asked my questions. I was going to ask the exact same two questions and make the same statement you made, that this, or maybe that actually Ms. Forbes made, that this is solely about rate structure. I'm sorry.
I stole
I'm
your
getting
thunder. Yeah.
Yeah.
I get to do that when I go first. It makes my job easier, right?
I appreciate you taking the lead all the time. So I don't think I have any further questions. I'm glad that discussion happened because I do think there's been some confusion, and I want to make it as clear as possible for the general public or whoever might be, listening in on this issue. What is before us today?
Thank you, Commissioner Lindley. Commissioner Ginecca, do you have any questions for staff at this point?
I only had one question, and first of all, thank you, whoever muted their microphone just now. I appreciate that. Good audio etiquette. I'm sorry, Commissioner Lindley, I think it was a little echoey when you were speaking earlier, but I captured your input and your comment, and I have to agree as well. Chairman, I had two very prominent and clear questions that I had to strike off of my notes here, so thank you for asking those. But the question that I had for staff was, it wasn't clear to me in backup on this matter whether the additional notice was provided by the operator of the compact facility. I believe the rules require an additional notice of the rate change be sent to customers. Is that correct? Would you be able to confirm that for me?
Yes, Commissioner Ginecca, that was provided to the customers, and we received no requests for a contested case hearing.
Okay, thank you very much. And I just wanted to make sure that I did confirm that because I did seem to recall that this was unique in other rulemaking matters and that there are very specific requirements that our agency requires. Prior to proceeding as a typical rulemaking, there is a notice, a public notice, and opportunity for a contested case hearing specific for this type of matter, and that again you can confirm has occurred, and there were no requests from those customers or any of the noticed parties
that preceded the Texas Register publication of this rule change itself?
That is correct.
Thank you for confirming. I don't have any other questions at this time.
Thank you, Commissioner Ginecca, and thank you, Ms. Forbes, for the presentation. I understand that we do have people signed in to speak on this item. So, Ms. Smith, maybe I'll leave it to you to go ahead and call the interested persons.
Okay, I think what I'm going to do is just go down the list as I have them. Then the first person is Susie Bell, Miss Susie Bell Gossley.
Very specific requirements that our agency requires prior to proceeding to the typical rulemaking. Ms. Gossley, you might need to mute your stream right now. I think we can hear it through your microphone. Has occurred, and there were no requests from those customers or any of the notice.
Folks, my audio is not real good. If we could pause and maybe remute the lines, and then we'll have the first interested person called again. Ms. Smith, you'll do that, and we'll try this again. Ms. Smith, could you identify that first person and invite them to speak? And let me just add the admonition that we want comments that are germane to this rulemaking and don't wander into other topics. But Ms. Smith, why don't you go ahead and call the first person again, if you would?
So I'll try this one more time. Susie Bell Gossley.
Ms. Gossley, are you on the line? Ms. Gossley? Ms. Smith, I'm not hearing Ms. Gossley. Maybe we can return to her if you want to call the next person.
We'll do Miss Karen Haddon.
Good morning, Ms. Haddon. Are you there? Ms. Haddon, I'm not hearing you either. If you want to check to make sure your line is not muted. All right, why don't we come back to Ms. Haddon? Who's next, Ms. Smith?
Next on the list is Miss Becky Halpin.
Good morning, Ms. Halpin. Are you there?
Yes, I am. Can you hear me?
I hear you loud and clear. Thank you. Good morning. Thanks for calling in.
All right, the muteless me. All right. Good morning. I'm Becky Halpin, and I am speaking on behalf of myself, and I believe I speak for many other Texas citizens. There will be a very direct impact to the public with loss of millions of dollars in reduced fees, reduced rates, and eliminated fees this agenda item proposes. This puts an increased burden on the citizens of Texas to cover for these losses. TCEQ is forgetting that the state must also be profitable, so to speak. The state of Texas will be asked to provide for the ultimate safety and security of the radioactive materials in this facility for the protection of our citizens. We will be asked to maintain and pay for the roads this company uses to bring materials to this facility. Texas citizens will be asked to pay for management and cleanup of any incidents or accidents relating to the transportation of radioactive waste as it moves across our state. It is not a matter of if Texas will pay, only when. These rates and fees put money in Texas coffers to cover the cost now and in the future. The state of Texas is looking at a pretty dry kitty right now. It is not time to deprive the state of money from these very fair fees. It is up to TCEQ to protect the interest of the citizens of Texas, not the profitability of a corporation doing business here at our expense. Please leave these rates and fees unchanged or extend the comment period, which was very fast and very short before you take a vote, so many people who had no idea this was on your agenda can weigh in. Thank you very much.
Thank you, Ms. Halpin. I appreciate your comments. Ms. Smith, I'll ask you to call the next interested person.
The next person on my list is Ms. Linda Hanratty.
Good morning, Ms. Hanratty. Are you there? Ms. Hanratty, I'll ask you to double check your microphone and make sure you're not on mute. Ms. Hanratty, are you there? Ms. Smith, why don't we go to the next one, and we'll loop back to Ms. Hanratty.
Okay. And I think I just got a message that Ms. Hanratty no longer wishes to speak, so I will cross her off the list. The next person on my list is Ms. Meredith McGuire.
Good morning, Ms. McGuire.
Hello. Yes, can you hear me?
You're coming in loud and clear. Thank you very much.
Great. Thank you. Thank you very much for this opportunity to speak to the TCEQ today. I am Dr. Meredith McGuire, recently retired professor at Trinity University and co-author of a widely used medical sociology textbook that deals with preventable causes of sickness and death, such as human-produced ionizing radiation. I am wondering why the TCEQ is even considering rulemaking about the issue of proposed huge reductions in the state of Texas's Curie inventory charges to the WCS repository for radioactive waste deposited there. Surely the TCEQ does not consider bringing tons of radioactive nuclear waste into our state to be an environmental improvement. It's appalling that the state of Texas did not demand much, much more from WCS repository in the first place, because it is the people of Texas who will have to pay in taxes or in health risks when WCS folds after maximizing its profits for several years and leaves a highly dangerous waste unmonitored, uninsured, and increasingly impossible to transfer safely to a satisfactory permanent repository. The safest place for interim or permanent storage of radioactive waste from nuclear power plants is encapsulation on site, where it is at least likely to release dangerous radioactive emissions due to accidents in transit. Knowing now that the WCS has also applied to the Nuclear Regulatory Commission for permission to accept ultra-hazardous and life-threatening high-level radioactive waste, Texas must increase the demands on WCS proportionately to the greatly increased risks of bringing such dangerous material into our state. The state should require both the sending company, Northstar, and WCS to post insurance bonds sufficient to cover any and all accidents related to that radioactive waste in perpetuity, even if the companies go bankrupt. I urge the state of Texas to refuse to accept high-level radioactive waste and to refuse to allow transport of high-level radioactive waste on railways and highways across our state. And I urge the TCEQ to refuse to make a ruling that enriches corporations that are literally dumping on Texas at the expense of the people of Texas. Thank you.
Thank you, Ms. McGuire, for your comments. Ms. Smith, will you call the next person?
The next person on my list is Ms. Sharon Ritchie.
Good morning, Ms. Ritchie.
Hear me?
I do hear you. Go ahead, please.
Okay, this is Sharon Ritchie. Thank you for your careful consideration in these important matters. My request is there be no WCS rates reductions. Hopefully TCEQ will provide more information as to details of how any such rate changes would impact fees to the state so the public can be more informed as to what is entailed in the requested changes. It's been said the state might experience losses of otherwise income of $3 million, possibly up to $25 million or more. These funds lost could have been used for public health and safety related to radioactive waste disposal. These monies have been agreed upon. Please hold these parties to their agreements. Thank you.
Thank you, Ms. Ritchie. Ms. Smith, please call the next person.
Mr. David Rosen.
Good morning,
Good morning,
Mr.
Chairman. Yes, good morning, Chairman and Commissioners. I am David Rosen in Midland, Texas. I'm a geologist, and I'm of the belief that the licensee really has no competition, but yet their request is based on needing to make a profit and needing to beat out their competition. Well, their request for dramatic lowering of their fees of 87.5% is just absurd because there is virtually no competition. And the state, given the fact that there are dramatic decreases in oil and gas severance taxes and sales taxes in the state, certainly needs the income to support the good work of the TCEQ and the other agencies of the state and the rest of the state government infrastructure. Furthermore, I think the write-up that was presented regarding this issue in the legislature was somewhat incomplete. After all, the licensee requested this rate through the legislature, and it didn't make it out of committee. However, it was added to a completely different bill. It was completely unrelated, and it was added as an unrelated amendment. And however, our governor, who has said he doesn't want Texas to be turned into a nuclear dump, was wise enough to veto this legislation because of that unrelated amendment. I hope you will reconsider the idea of lowering these rates by 87.5%. Thank you.
Thank you, Mr. Rosen. Ms. Smith, if you'll call the next person.
Mr. Adrian Shelley.
Good morning, Mr. Shelley.
Good morning. Can you hear me?
I can.
Thank you, Mr. Chairman. Adrian Shelley with Public Citizen, speaking in opposition to the rule. Appreciate the opportunity to speak this morning. As a point of process, I'll note that I've spoken with both of our first two registrants, Ms. Susie Bell Gosley and Ms. Karen Haddon. Both of them had technical difficulties with computer audio. Ms. Gosley has signed in using a phone. Ms. Haddon is doing so now, so hopefully we can circle back to them. I am, and Public Citizen is speaking today, again, in opposition to the rule and continuing our long effort to oppose Waste Control Specialists' continued effort to move the goalposts on nuclear waste disposal and storage in Texas on many fronts. I appreciate the distinction that we heard about the scope of this rulemaking. We understand it's just a question of the rate structure today, but the simple fact is if the rates are reduced, WCS will see less revenue. This will create additional financial strain on what we see as an incredibly tenuous situation already. The rulemaking package notes that there are potential controversial concerns and legislative interest with this rulemaking. My colleague, Mr. Rosen, articulated those pretty well. We have had bills in the House and the Senate and a bill vetoed by the governor in the last session. And I'll just reiterate that the governor has said quite plainly, quote, some people want to make Texas the radioactive waste dumping ground of America. I won't let that happen, end quote. I understand that this rule is limited in its scope, but I think that quote speaks to the governor's frustration about continued efforts by WCS on this front. And so that brings us to the present position. We have a rule that has had no stakeholder meetings, no comment, no request for contested case hearing. It is being proposed as a minor environmental rule during a global pandemic and unprecedented health crisis. And frankly, the stated justifications for the rule just don't add up. WCS says it needs to be competitive, but the company's own website says that it is the only commercial facility in the United States licensed to dispose Class A, B, and C low-level radioactive waste in the last 40 years. It does not appear to have competition. WCS says that it needs to be profitable. First of all, it's not really the TCEQ's objective to make a private corporation profitable. But it's entirely unclear how lowering fees, changing the fee structure to reduce fees, would make the company more profitable. It's just unclear. We think that the TCEQ's first and final mandate should be the protection of public health and safety in the state. We are asking the TCEQ at the very least to delay this rulemaking until we can undertake a complete and legitimate stakeholder process. Ideally, we would encourage the TCEQ to follow the clear intent of the legislature and the governor and leave it up to them whether we give WCS another handout. So thank you for your time. And again, I really hope we're able to hear from Ms. Gosley and Ms. Haddon today.
Thank you, Mr. Shelley. Ms. Smith, if you'll call the next person.
Mr. Robert Ban.
Mr. Ban, are you there?
Can you hear me?
I can. Go ahead, sir.
Okay. I will be concise, and I'm basically reiterating what the folks have already said. Our elected representatives decided clearly not to reduce these fees. Our governor vetoed the good bill, which the reduction would have been surreptitiously attached because of that attachment. Texas, because of the coronavirus and its effect on oil and gas production, is in serious financial difficulties. Waste Control Specialists is just demonstrably not in need of this reduction. So why would we do an administrative reduction when all of these folks who are representing the people of Texas have said no? That's all I have to say on this. Thank you.
Thank you, Mr. Ban. I appreciate your comments. Ms. Smith, call the next person, please.
Mr. Cyrus Reed.
Hey, good morning, Mr. Reed.
Yeah, good morning. This is Cyrus Reed with the Lone Star chapter of the Sierra Club, here to speak in opposition to the proposed rulemaking today And I do want to apologize to the commissioners and to the TCEQ for, I think a number of us missed this item and did not comment during the public comment period, and usually we're pretty good about that. I think we all just, for whatever reason, missed this rulemaking, which was rather hastily done. And
well, we're glad to take your comments now, but thank you.
Yeah, well, we do recognize that the proposed rulemaking doesn't specifically impact the surcharge or the state fee directly, but by lowering the fee for curies, it absolutely does. What we don't know is what the real impact of that is. And so at the very least, I would ask the commission to delay taking action on this rulemaking and to do some sort of a economic look at what the impacts of lowering the curie limits would be. Because honestly, whether you work for an environmental organization like I do, or one of the legislators that clearly rejected this change, you don't actually know what a reduction of 87% in the curie fee will do to overall revenues that could come to the state or frankly to the county or to Andrews County. And so at the very least, I would ask you to not take action and conduct some sort of analysis so the public and the legislature has a better understanding of what the impact of this reduction would be. And I'll end it there, but I would ask you not to move forward today on this rule.
Thank you, Mr. Reed. I appreciate that. Ms. Smith, if you'll call the next not party, but interested person.
Miss Susie Bell Gossley.
Ms. Gossley, are you there? We still don't hear you. Maybe you're on mute. If you want to double check that.
I'm not.
Ms. Gossley, we're getting an echo that's so bad that I can't hear you.
Is this better? Is this better?
Yep, I can hear you loud and clear now. Is that you, Ms. Gossley?
Thank you.
Oh,
thank you so much.
Okay. Please state your name and then go ahead with your comments, if you would.
I am Susie Bell Gosling, testifying as a member and on behalf of the League of Women Voters of Texas in opposition to the Texas Commission on Environmental Equality's proposal to change the low-level radioactive waste rates that WCS can charge by the curie and paid to the state of Texas. We appreciate the opportunity to speak to you today. Thank you for allowing us to share the League of Women Voters of Texas position on this proposal. We oppose the TCEQ Agenda Item 37 that will allow lower rates in one category from 40 cents to 5 cents. Our position, like other league positions, is derived through a lengthy and thoughtful process involving the participants of 34 local leagues throughout the state of Texas, representing more than 11,000 members and supporters throughout the state of Texas. Currently, the proposal being considered today is for lower rates that WCS would charge their customers, and as a result, lower the amounts of revenue that would go to the state of Texas. Texas would lose greatly by decreasing the revenue from current rates for disposal of low-level radioactive waste. The state's revenues are already down due to the coronavirus, so we cannot afford, we, the people of Texas, cannot afford to create greater financial losses to Texas and need to have full funding for remediation in case of radioactive contamination. The League of Women Voters of Texas is opposed to any loss of funds or fees from WCS to Texas. Both houses of the Texas legislature and the governor of Texas, Greg Abbott, did not approve of reducing surcharges that go to the state. The TECQ should not reduce rates that tied into state revenues in the end. The League calls on the Texas Commission on Environmental Quality to not approve the WCS rate reduction, which would ultimately negatively impact the state of Texas. Thank you for your attention.
Thank you, Ms. Gossley, and I'm grateful that we were able to get you on the line finally. I appreciate your comments. Ms. Smith, if you'll call the next person.
Ms. Karen Haddon.
Hi, can you hear me now?
You're coming in loud and clear. Thank you, Ms. Haddon.
Great, thank you. I agree with the previous speakers. I'm very concerned about this item. I think it should be postponed or withdrawn. We do not support the rate change, and I'm having a hard time understanding why the company involved would need this rate change. My understanding is that they're a well-funded operation, and I'm also concerned about who would benefit from this. It seems like there is no competition for Class B and C waste that's real. There's a little bit of downblending of Class A into Class A waste, but that is a very small amount of Class B and C waste in this country. So there is no other site licensed to take this B and C. That's where the big money is in radioactive waste. So why would we need to reduce rates? There's no competition out there. There's no reason for this. It's easy enough for WCS to charge the higher rates. My concern is that this is actually designed to benefit decommissioning of nuclear reactors. And there's an interesting tie-in in that the same person is the CEO of both waste control specialists in Texas and a decommissioning group called North Star. So are we doing this so that North Star gets a benefit, which is also composed of WCS, Burns and McDonnell, and Orano, the partner in this work? So what is going on? I mean, why would this be proposed? I think that they're an independent business. They need to be able to, charge what fees were agreed upon originally. And I don't think that they should be doing this, especially at the expense of the state of Texas. As others have pointed out, we need the revenues. We need the revenues specifically because at some point in time, there's going to be contamination that needs to be cleaned up. And we need to have that funding in hand to do that. And while this is not the surcharge, it's tied in because if there's decreased revenues by 87%, then that is going to tie into the amount of money that comes into state coffers on the tail end. I urge you not to pursue this, to withdraw it, and failing that, to delay and look at it again in the future. I think that the intent of actions by the legislature and the governor signal that they don't want to be giving away state funding. So I think we need to keep that in place. And thank you for your work, and thank you for the conversations I was able to have with staff on this issue.
Ms. Haddon, thank you very much. I'm glad we were able to get you on the line. I appreciate your comments. Ms. Smith, is there anyone else signed in to comment?
I don't believe anyone else was signed in to comment, but I had information that perhaps someone from Senator Zaffarini's office would like to comment, and so I'll pause and allow anyone from Senator Zaffarini's office to speak if they'd like.
there anyone from the Senator's office on the line who'd like to speak? Okay, hearing none, I think that takes us to the end of the interested persons, except that I do have some questions for WCS. I understand that Mr. Carlson may be available to answer questions. And sir, if you're on the line, I would like to understand what WCS views are on several of the comments, and let me flag for you some that are of interest to me. One would be, what is the need? We heard that question. What is the state of the competition? We heard questions about whether there was any question. What is WCS's view of how this would improve its competitive position? And what is WCS's view of how this would affect revenue to WCS, to the state of Texas, and to local governments, including Andrews County? And I read a long list of questions at you. I wouldn't expect you to get all that the first try, but I'll let you take a stab at it, and then I'm happy to repeat any of what I just said if you're available to tackle any of those, Mr. Carlson.
Great. Thanks so much, Chairman. Can you hear me?
I hear you loud and clear. Go ahead, sir.
Great. So first, let me take your first question. That's on competition. And I listened to Karen Haddon on that, and she's partly right, but the truth is that most BC waste can be down blended into Class A waste, and that's done, and ultimately disposed in Utah. So this is a very competitive market across the range of waste types. So that indeed is the issue that we have, is competition. So when the market price is lower than the price that we can actually charge, then of course we would get no revenue. We would get nothing from that, and that the surcharges that would go to the state would in fact be zero, as opposed to the 31.25% that's charged when we actually receive revenue. Let me clarify between.
I'm sorry to interrupt. Could I get you to pause there and just identify for us who the competitors are specifically?
Yes, sir. So the competitor for most of these types of waste is Energy Solutions in Clive, Utah.
Okay. All right. Go ahead.
Let me clarify another thing. There's two types of fees or surcharges that we're talking about. One that is set under the rule is the actual fee that is charged to the customer that comes to WCS in order to pay for operation of the business. The second is the surcharge, or the gross receipts tax, that goes to the state, that goes to the environmental remediation fund, that cleans up sites that others have contaminated around the site, that goes to Andrews County, or that goes to pay for the operations of the Compact Commission. So what we're talking about in rulemaking is those fees that come to WCS in order to operate the site, not the surcharges that were discussed in last legislative session and that are in fact in statute. So in terms of our view of what we think that this rulemaking would do, the intent of the rulemaking is actually to retain revenue that WCS has been receiving and allow us to price to a point where we would retain that revenue. In fact, what that would do is ensure that that revenue continues to come to us first, and then the surcharges applied to it would continue to come to Texas, to Andrews County, to the Environmental Remediation Fund, and to the Compact Commission, based on being able to stay competitive and being able to continue to properly dispose of those waste streams that we're talking about.
Okay, and just to be clear, you identified two things: that a fee that the customer pays to WCS, number one, Number two, the surcharge that comes to the state, the county, funds the Compact Commission's activities, goes to the Environmental Remediation Fund. Now, the surcharge is based on the fee the customers pay to WCS. Is that correct, or do I have that wrong?
No, that's absolutely correct. So that surcharge is currently 31.25% of gross receipts. And, my point on that would be that if the gross receipts are zero, if we don't get the work, then the surcharge to the state is zero as well. And when we are in a competitive position where we do receive that work, then the state would actually also receive money.
Okay. Thank you, sir. I appreciate that. That's answered my questions for now. At this point, commissioners, interrupt me if you'd like to interject at this moment, but I thought we would invite the views of our Public Interest Council now.
If I might, Chairman, I had one clarification of that, or a question to ask for Mr. Carlson, just to clarify.
Go ahead.
And then one other further follow-up question, if I might. Mr. Carlson, you said there's a 31.25% surcharge applied to that rate, the fee, rather. So the price that you charge customers, whether they're in state or out of the state, is determined off of the number that we're discussing today. That's what's at issue. And so those surcharges are a function of what the total fee number, the total amount. But the 31.25, is that for all customers, or is there a distinction to be made in out-of-state versus in-state customers there you might be able to clarify?
Yes, Commissioner Janica, customers that are in the Texas Compact, and that would include generators that are in Texas and generators that are in Vermont, would pay a lower charge. So they're paying, a reduced rate compared to that in terms of surcharge.
Does that number come to roughly 11.25 versus the 31.25, or is there a different math that y'all use?
No, that's correct. So they wouldn't participate in funding the Environmental Restoration Perpetual Care Fund. That is funded strictly by out-of-state contributions.
Perfect. Thank you. And my next question is just specifically, will this proposed change in the rate, does this factor out or work out in your company's estimates to a functional disposal fee that provides sufficient revenue for operations and all the costs needed to operate the facility, et cetera?
Yes, Commissioner. So as you know, most of the costs of our facility are fixed costs that are there regardless of how much waste we would take into the facility. So our intention is to maximize revenue to the point that we have adequate revenue to cover the cost of operation, and that is absolutely our goal here. We are focused in that area.
So effectively, your expectations are that being free to charge a lower price, you may in fact be able to successfully compete for and bring wastes in an increased volume that offset the apparent reduction in fees. Is that part of the complexity in trying to estimate the fiscal impact of the state? That's the one piece I'm really interested to get at specifically.
Yes, sir. That's absolutely correct. So as we look at this, our goal is to maximize the revenue that's available. We're certainly not looking to minimize our revenue. And so as we maximize revenue to the company, that also maximizes surcharges to the state. So if we're operating in the best interest of the company, the way that the surcharges or the gross receipts taxes are established, the state and the local county benefit alongside of us.
Okay, thank you. No other questions for me.
Thank you, Commissioner Janica. Commissioner Lindley, did you have anything, and I'll give everybody opportunity to speak again later, but did you have anything to add or any questions before we let Mr. McWhorter speak?
No, I think y'all have asked all the questions I would ask. I might have comments in a minute, but I don't have any further questions right now. Thank you.
Okay.
Chairman?
Yes.
Before we move on to OPIC, a representative from Senator Zaffarini's office has now joined the call and I believe would like to address the commission. Ms. Krista Kyle.
Yeah, fair enough. Let's do that. And I'm sorry, the name again?
Ms. Krista Kyle.
Ms. Kyle, good morning. The floor is yours. Go ahead.
Good morning. Can you hear me now?
I can. Thank you.
Perfect. I apologize for the technical issues earlier. This is Krista Kyle again on behalf of State Senator Zaffarini, and I just wanted to read a letter from her this morning. Dear Chairman and Commissioners, thank you for your leadership in addressing our state's environmental issues. This is to respectfully request that the Texas Commission on Environmental Quality reopen and extend the public comment period and postpone the July 1st, 2020 rulemaking decision regarding the disposal of low-level radioactive waste, Rule Project number 2020-009-336-WS. I also ask that additional information be provided to legislators regarding this proposed rulemaking based upon questions raised in this letter. Yesterday, I was contacted by concerned stakeholders who were not aware of the proposed rulemaking until after the comment period had closed on June 9th. As you can imagine, they felt blindsided as a result. Especially given the extraordinary nature of the ongoing pandemic, I believe their concern is well-founded and should be addressed appropriately by the Commission. As you are aware, the Texas legislature did not support changes to the low-level waste disposal fees proposed last session. Neither Senate Bill 1021 by Senator Kel Seliger relating to the operations of the Texas Low-Level Radioactive Waste Disposal Compact Waste Disposal Facility, nor its companion, House Bill 2269 by Brooks Landgraf, was considered by its respective full legislative body. What's more, a last-minute House amendment proposing similar fee changes to an unrelated domestic violence bill, Senate Bill 1804 by Senator Lois Kolkhorst, was rushed through on third reading without thoughtful explanation. Governor Greg Abbott later vetoed this bill specifically because of that amendment. Given the clearly contentious nature of this issue, it would be helpful for TCEQ to inform legislators about the rate changes proposed in this rulemaking prior to its implementation. I also have serious concerns about the unknown fiscal impact to the state of this proposed rulemaking. According to its fiscal notes, fiscal implications are probable for the agency and for other units of state or local government as a result of administration of the proposed rule. However, due to market competition, the implications cannot be determined. How then can it be argued that the proposed rule does not meet the statutory definition of a major environmental rule because it would not adversely affect in a material way the economy, a sector of the economy, productivity, competition, jobs, the enforcement, or public health and safety of the state or a sector of the state when the fiscal implications of the proposal cannot in fact be determined? Similarly, how can it be argued that the public health and safety should not be affected by the proposed rulemaking when at the least it has the potential to reduce state funding to the Environmental Radiation Perpetual Care Account for the remediation of radioactive contamination from past or future accidents, incidents, or leaks? The argument for the rulemaking appears to be couched in terms of enhancing competitiveness for WCS and ensuring the company does not operate at a financial loss. But the claims regarding the company's need to remain competitive ring hollow. Energy Solutions in Utah appears to be WCS's only nationwide competitor and accepts only Class A waste, the least radioactive category of LLRW. Shouldn't the proposed Curie charge reduction likewise then be limited to Class A LLRW? Reading the proposal begs further questions. How was such a significant percentage reduction of 87.5% determined? Who exactly would the proposed rulemaking benefit at the potential expense of millions of dollars to the state? Is the proposed rate change related to the fact that WCS reportedly now is involved in nuclear reactor decommissioning as well as the disposal of LLRW? Is WCS thereby benefiting from both ends of the deal and disposing of this waste? What's more, North Star Through Services reportedly has purchased Entergy's Vermont Yankee nuclear reactor, and its decommissioning team includes Orano USA, WCS, and Burns & McDonnell. According to WCS's website, Scott State is CEO of both WCS and North Star. To what extent would the rulemaking benefit North Star as opposed to simply WCS? How much state revenue would be lost over time when considering the major upcoming decommissioning projects, including that of Vermont Yankee? How would the proposed rate change impact the amount of waste being sent to the WCS site? Given our current circumstances, the public needs additional time to consider and to weigh in on this rate change and the real impact it could have on Texas. Accordingly, I respectfully request that TCEQ, at the very least, consider and provide answers to the many questions raised herein, reopen the public comment period, and postpone its rulemaking until after these questions and public comments have been reviewed and analyzed. The high-profile nature of previous discussions regarding related fee changes also warrants TCEQ's consideration of this issue as a major amendment, not simply as a rulemaking. My prayer is that the Lord will bless you and inspire you to agree with my perspective. Feel free to call upon my staff or me whenever we may be of assistance. Very truly yours, Senator Judith Zaffirini.
Thank you, Ms. Kyle, and thank Senator Zaffirini for submitting the letter. I appreciate that. I think our Office of Public Interest Counsel is up now. Go ahead, Mr. McWhirter.
Thank you. Yes, after hearing the comments of folks today, and it is curious to me that there were no comments received. I have no doubt that we followed the appropriate procedures in publishing the item, but it seems clear that there were interested persons who did not really, for whatever reason, be it related to the pandemic or other pressing matters, weren't attentive to the fact that they had an opportunity to provide input on that. And for that reason, I'll limit my comments just to the procedural matter. I would support the requests that have been made to continue this matter and reopen the matter for public comment and maybe some outreach efforts to so there'd be forums for explaining the basis for the decision, perhaps in more detail than we've had the opportunity to do so far. And that'll be the limit of my comments today.
Thank you, Mr. McWhirter. I appreciate that. Colleagues, before I get to our discussion, I would like to put another question to Mr. Carlson that I didn't before, and it's responding to points that both Ms. Haddon made and Senator Zaffirini made regarding the relationship between entities decommissioning radioactive sites, including North Star, the relationship between North Star and WCS, and the nature of those transactions. And Mr. Carlson, if you'd like to speak to that issue, I'm happy to hear your comments now.
Absolutely. So between North Star and Waste Control Specialists, we do have completely independent boards from each other, and we're independent companies. So neither one is owned by the other. There is no cross ownership or anything like that. The Vermont Yankee decommissioning is indeed in the compact, and so the rates that we're discussing actually set a ceiling on the highest price that can be charged to Vermont Yankee or to North Star for the work on that job. Of course, those rates were agreed on years ago, but this is a ceiling for in-compact generators, so a reduction in that ceiling and a floor for the rates that are available to out-of-compact generators. I would like to reiterate, though, that if we don't have the opportunity to be competitive and actually receive the waste that we have historically been receiving, then ultimately there are no surcharges that are used to pay for things like the Lamprecht-Zamzow cleanup and other cleanups, primarily of uranium mines and so on, that need to be done around the state.
I appreciate that, and I have a follow-up question. I'm going to try having difficulty framing it or articulating it. I understand your math that if your fee is too high, that your competitor, Energy Solutions in Clive, Utah, through downblending or other means, can accept that waste instead. And if your fee is too high, the revenue is zero, meaning the surcharge to the state and county, et cetera, is also zero. So I understand that. Has WCS endeavored to quantify what the effects would be to the state, in some range or hard numbers, if you could charge the market rate? And maybe I could ask you, where is the market rate now with respect to the flexibility that is being contemplated in this rulemaking?
Right, and there's a range of market rates, Chairman. So every individual shipment of radioactive waste has both a basic dollars per cubic foot charge, which is the primary charge to that generator, and then a small fee in addition to that would be the Curie surcharge. And so as the Curies become higher in the particular waste stream, that charge goes up. My understanding of the competitor is that their Curie surcharges are not similar to ours, and so we become uncompetitive as those Curies increase.
Okay. Thank you for that. Colleagues, I think we've heard from staff. We had a chance to hear from WCS. We heard from quite a few interested persons, Office of Public Interest Counsel. I, as chairman, normally lead off and share my thinking on these matters first. And in this case, it strikes me as appropriate maybe to defer to Commissioner Ginecka to help organize this, given his experience with this program. I think he has deeper experience than you, Commissioner Lindley, or I do. So, Commissioner Ginecka, I hope I'm not putting you on the spot, but if you don't mind, let's lead off with your observations on this matter.
Yes, sir. Thank you so much, Chairman. And I'm a bit conflicted myself, only in terms of trying to hear from each of you. I'm curious to know to what extent you all may share a concern that I have, just particularly zeroing in on one comment in the letter from Senator Zaffirini at the end of the third paragraph, full paragraph. Given the clearly contentious nature of this issue, it would be helpful for TCEQ to inform legislators about the rate changes proposed in this rulemaking prior to its implementation. And I'll just say that I fully agree with that statement and am very sensitive to it. I think we always endeavor as an agency to keep our interested stakeholders across the state informed, but I think that's a point very well taken, and I feel a bit remiss myself in not more proactively asking of ED staff what conversations we've had and tried to support that conversation happening. I think if nothing else, this is a good reminder to us as an agency that this issue, while somewhat narrow in scope and routine in our scope over it, really does touch on a somewhat charged, for no pun intended in the word. It is a ongoing and live political, an active policy discussion that continues to be underway at a level above our commission. And I think that many of the comments that we've heard today really do go directly to those policy issues addressed under the statutory changes that have been proposed and acted on or not acted on by the legislature, governor, state leadership. Effectively, what we're looking at here is a rate setting for a fee, and that is a big important difference that I think Mr. Carlson made and many of the commenters alluded to. But the state fee, the established set regulatory rate is different than the surcharges that were proposed to be changed last session, and so I think that our commission has been given some clear statutory direction and some criteria with which we need to set that fee and keep in mind as we are determining it. And this rulemaking, this item that's before us, reflects that process, and I believe that the process was followed appropriately. I think that given the fact that there is a notice step to customers, an explicit statutory opportunity for a contested case afforded to customers in the state, I think that there are many steps that give opportunities to participate in the appropriate manner, given that this is setting the rate, and it deals with things such as what costs are appropriate to include and incorporate into the rate base. And I think part of the challenge that's being revealed in these comments is the fact that this issue goes to the heart of, I think, an ongoing issue of public policy in that Texas has taken steps unique from any other state in the country. Decades ago, Congress acted and gave the states broad authority to run and form compacts and build sites and take care of your low-level waste issues on your own. The federal government has one issue or one area, the states have another. And since that time, no sites have, this is the first site to be constructed, and Texas continues, I think, to be a leader in trying to perfect the model in building a site to modern day standards. And that's where we see a lot of consternation directly around price. We're looking at a marketplace that has some options, some disposal options reflecting prior standards. And I believe that there are some real cost factors that go into that where there is just a higher cost for disposal reflected in disposal here in the Texas site relative to other sites elsewhere in the state. All that's to say, those are all valid issues for discussion, but I think they really go to policy discussions best left to the legislature and to state leadership in that regard, whereas our commission is charged with considering changes to this regulated rate, which, again, doesn't operate like any other regulated rate, quite like that. It's an interesting market to try to apply this policy solution to. And I commend our agency staff for trying to do, for always trying to split that very complicated question. But I think in terms of the matter strictly before us, I'm satisfied that the discussion around the rate with the likely interested parties occurred appropriately. We did not hear from any customers, this is not a rate increase. And so in terms of the commission's authority here and the question before us, I'm not troubled with the prospect of moving forward, and I would be comfortable having further discussion with either of you if you want to discuss that prospect. Conversely, out of respect for the agency's the obligations we always take very seriously to keep our state leaders and the members of the legislature informed, I'm also equally comfortable if Commissioner Lindley or Chairman Neerman, if either of you feel heartburn with proceeding today and would like to take more time, but I'm really just curious to get input from each of you specific to that issue. I don't think it's the first time our agency has been pulled in on a live political issue that really needs to have its day in quote unquote in court in the legislature on a matter that's tangential but really strictly unrelated. So this may not be any different in that respect, but it is always a bit of a unique issue. So I would love to hear from each of y'all on that point specifically.
Thank you. Go ahead, Commissioner Lindley.
Well, let me just say this. I have one pretty basic question, but I'm just trying to wrap my head around it all. And then I would like to ask for a 5-minute break after my question gets answered, just to pause for a minute. But here's my question. So what's before us today is, let me back up. There's kind of two different issues from what I can gather. The veto that happened last session on the bill was more about the surcharge. And what's before us today is more about a rate change. Is that accurate to say? And I don't even know who's the best to answer that. But that's kind of probably a basic question I just need to clear up in my head. How different is the bill than, what was vetoed than before us today as far as a rule?
I think that's a great question, and I don't want to claim to be the one who should answer that, but my understanding is that
you can take a stab at it. I'll welcome that.
The bill, the vetoed bill, that dealt explicitly with the surcharge, with the additional 20% charge and 5% charge to the state. So that vetoed bill would have extended a temporary reduction, reducing one surcharge and zeroing out another surcharge. They had been zeroed out and were set to expire at the end of the next fiscal year, approaching the end of the session. So the bill did explicitly deal with the surcharge. and that is the percentage state surcharge applied to the per customer price, the fee. And this rulemaking deals with the rate itself, the fee that our agency sets, and that price, which is determined or set in reference to this fee. And I'll, without trying to complicate the issue any further, I will point out that this fee serves as a floor for any out-of-state customers. They may not, WTS may not charge them a price for disposal that falls below this set amount, this fee that we would propose to set in our rule. And for in-state customers, for those in Texas or in the state of Vermont, because they are our partners in the Interstate Compact, they are capped at the fee that we set. And so customers in our state or in the state of Vermont are guaranteed a price no worse than that fee set. And so I think it would be appropriate to take your question, Commissioner Lindley, and pass that on to Executive Director staff to respond to it. But my understanding, just to take my first stab at it, is yes, you're right in the question you're getting at. There are two different things here. The legislative action really did directly point at the surcharge. The rule matter before us directly involves or addresses the fee. And I'll stop there and see if we might put the question to ED staff or if we have any other questions for discussion, but maybe pausing here is a great time for everyone to collect thoughts.
Why don't we, Commissioner Ginecca, go ahead and invite Ms. Forbes to answer the question, and then we can take the break that Commissioner Lindley requested. Ms. Forbes, would you like to take a stab at that?
Thank you, Chairman and Commissioner. Certainly, I don't have much to add to what Commissioner Ginecca stated. I was concerned by some of the comments today from stakeholders, and that's exactly it. These are separate but tied issues. What was vetoed was the surcharge. And again, as we have our obligations in 401 to periodically review these rates, and we found good cause to change that. But that the rate is definitely what is charged to the generators. And as Commissioner Ginecca pointed out, it is lower for the in-compact Texas and Vermont generators and higher for out-of-party generators who would be presumably bringing rate waste into the state of Texas with permission of the Texas Radioactive Waste Disposal Compact Commission. So when that waste is brought in, there's a surcharge that ultimately goes to the environmental perpetual care, radiation perpetual care account. So those are separate things that are all tied to the price that WCS obviously passes on to their customers. I hope that helps.
That helped me. Thank you.
Thank you both.
Commissioner Lindley, would you like a break?
I would love just a quick break, and we can set a time, or I can just.
Why don't we do this?
Come back in.
It's 11:13 now. Why don't we reconvene in about 5 minutes? Is that enough at 11:18?
Maybe 10 to be safe. Yeah.
I'm sorry, 11:20?
Maybe, what time do you have? Maybe 10 minutes to be safe.
Okay.
Thank you.
So just to round it to an odd number, let's take a short recess and reconvene at 11:25.
That sounds great.
Okay. We stand in recess until 11:25 a.m. All right, folks, it's 11:25. We're back after a short recess. We're still addressing item number 37, rule matter concerning adoption of radioactive substance fees. And let me take a roll call. I'll make sure we still have a quorum. Commissioner Lindley, are you there?
I'm here. Thank you.
All right. Well, that's a quorum right there. But Commissioner Ginecca, are you here?
We want him here.
I am.
Yeah. Okay. Well, if the two of you are on the line, I've got some other things to do, so I'll just catch up with you later if that's all right with you.
No.
Yeah. All right. No bad joke. Right. Commissioner Lindley, can I turn it back over to you and we'll gather your thoughts?
Sure. I'll start. I've written down so many little notes here while I was thinking and talking, so I'm going to try and make them make sense out loud and not just in my head. So I do think this one is, it's a little difficult, and there's something about the topic of radioactive waste that just makes everything more complicated. And that's okay, because it is a serious topic, and we need to take it seriously, and we need to do deep dives into it. So I'm glad we've had a lot of discussion today on it. You know, at the end of the day, yes, there was a bill last session that was related to the surcharge that was vetoed. That's a fact. And I do believe the governor has stated it very clearly, his thoughts on high-level radioactive waste. That said, what's before us today is a rate change. And I do think that fiscal changes are probable as far as what the state's going to see at the end of the day from this site. A fee or a rate change might affect how much comes in the door, might also affect how much doesn't come in the door. And so I don't think those implications can be determined, and I'm not sure that's really what's technically before us today as well. But there were a lot of people that commented on that, and just wanted to make that comment as well, that I do think there are probable changes. I just don't know what those implications are yet. I just think that's tough to predict. So, you know, what's before us today is the rule, and the Texas Health and Safety Code 401.245 does require the Commission by rule to adopt and periodically revise party state compact waste disposal fees. And so that's what I keep going back to, is that's what's required and that's what's before us today. There were no comments received, and it's just, it's difficult when there aren't any comments received and then it's before us, and, it just would have been nice, and I know some people commented on this, that they recognized they didn't comment along during the process. And I wish we had heard from them sooner as well. But at the end of the day, procedurally, I think this rule meets all the requirements. And so even if I took, personally, I'll be very candid, even if I took more time to think on this, which if someone wanted to toss that option out, I could probably get there. I don't want to open public comment, but I could be comfortable with, taking up at another agenda. But I think at the end of the day, for me, procedurally, the requirements have been met. And so I'm not sure, even if I sat on it for a while and thought on it, I might have more questions, but I'm not sure at the end of the day I would come down with a different answer. So I think I'm comfortable moving forward with what's been presented to us today. The discussion was very helpful. The comments were very helpful. And I'll stop there and see what you gentlemen think.
Appreciate that. Commissioner Ginecca, additional thoughts?
It's like you're reading my mind. I had the exact section of the Texas Health and Safety Code up on my browser right now. It's just reviewing it, and I see that one of the factors that our agency is charged with viewing is the periodically revising the party state compact waste disposal fees according to a schedule that is based on the projected annual volume of low-level radioactive waste received. Clearly, the legislature recognized the complexity here and handed to our agency the practical application of reviewing this and taking our best efforts to make it workable. And this is a bit unusual because the rate mechanisms work a bit perversely here. This is not a regulated utility like a water utility or a power generator that customers are hooked on the grid and must have that good. And so the rate calculation is not simple, but it's a simpler equation. And as the customer demand goes up or down, that has a very direct and clear impact on the rate. Well, here we're dealing with several complicated factors that don't fit into that traditional rate model. And I think it's fair game for our agency to be called and to look at as those annual volume disposal projections increase or decrease, or as they bear out higher or lower than what is anticipated, that will have a natural impact on the rate. And again, I'll reiterate, the customers, the individuals who would be entitled to a contested case on this proposed change, they did receive and did, I presume they opted not to exercise that opportunity to contest this action and to seek further discussion on it. So I think that I'm very much in alignment with Commissioner Lindley's views on it as well. I appreciate hearing that.
Thank you, Commissioner Ginecka. And yeah, I think I'm fairly well aligned with what you both have laid out in terms of TCEQ putting together a proper rule package consistent with the law. We are not doing anything in contravention of legislative intent. If the legislature did give us instructions through a statute, we would certainly follow them. I'm just going to tick through some of my notes and thoughts. It's difficult on any rulemaking package when, for whatever reason, we don't get comments during the notice and comment period, and instead are scrambling with arguments being presented the first time with minutes before the agenda starts. So it's difficult, but nobody promised that our jobs will be easy, and it's our duty to hear those and respond to those. In terms of effect on Texas revenue, now it strikes me that this is not a normal market at all. Commissioner Ginecka, kind of responding to some of your comments, we have a very small number of players, and it's a very unique industry. And so, traditional supply-demand analysis, I think, is not, perhaps a completely adequate tool to understanding this. But it does seem to me that WCS's interests, generating revenue and profit, are aligned with the government's interest in collecting tax revenue. So for what that's worth, I think that's correct. The more revenue and more profit even that WCS has, the more revenue to state and county coffers. All of that said, I am ready to move forward and adopt this rulemaking, but for all the comments we heard this morning. And so what I would propose, colleagues, is that we continue this item to our next agenda for the purpose of doing whatever additional homework each of us thinks we need to do to get comfortable with this action, but also doing appropriate outreach to the stakeholders and commenters, particularly the legislative offices that have been in touch with us this morning, so we can be certain that we're hearing their concerns and give them a chance to educate us and give us when I say us, give staff a chance to educate their offices about what this rulemaking is and is not. So what, colleagues, what do you think about a 2-week continuance for those purposes? And then we'll strive to make a decision on this item at the next agenda. Commissioner Lindley?
I would be okay with the continuance just until the next agenda. I think 2 weeks is plenty of time, but just to be, so I know for sure, when we do that, we're not opening up the public comment period. That's my understanding, and that's what I would prefer, but I just want to clarify that.
Yes, I have no intention to open the public comment period at this agenda. I think, given what I know now, I think it's unlikely at the next agenda, but I'm going to hold open the possibility that I could be persuaded otherwise. So we're not making we're not taking any action here to open up the comment period or go forward with this rule. We're just allowing ourselves another week to consider it. And because it's a rulemaking and it's not a contested matter, we're free to have conversations with folks about this. So it'll give us an opportunity to educate each other, I think. Not the commissioners educating each other. The only people who can't talk to each other are we 3 commissioners. But each commissioner can talk with stakeholders and staff, interested people to the extent they want to do that, and vice versa.
That's fine with me. I would be fine continuing to the future agenda with the goal of, taking it up at that agenda and finishing it off so it doesn't, I'm fine with that.
Commissioner Ginecca?
I certainly have no objections either. I was wanting to offer, if the preference was to take action today, I wanted to offer myself as a ambassador to jump first into the fire out of our frying pan we find ourselves in terms of trying to lead discussions or participate in discussions from this point in the agency with the legislative stakeholders to the extent that we could try to address and clarify concerns moving forward. But I think having a 2-week pause certainly gives ample opportunity to have discussions that may need to occur and answer questions to the fullest extent. So I'm not at all opposed to that, and I'm certainly happy with that proposal.
Good. Maybe we'll start calling you Ambassador, Commissioner Ambassador. I would, love for you to take on that ambassador role. Well, Ms. Smith, do we need a motion on this to continue it, or can we just declare our intent to continue this item to the next agenda?
I guess best to make a motion.
Okay, colleagues, I move that we continue item 37 to our next agenda.
I second.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecca, how do you vote?
Aye.
I also vote aye. The motion carries. Thanks everyone for their discussion on this, and we'll get a chance to have yet more discussion in a couple of weeks. And that takes us to item 38. Ms. Smith, if you'll call that item, please.
Item 38 is the consideration of the adoption of the Federal Clean Air Act, Section 179B demonstration state implementation plan revision for Bexar County and the 2015 8-hour ozone national ambient air quality standard non-attainment area. The executive director's staff is here to present these items.
Thank you. Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Brian Foster of the Air Quality Division. I am joined by Terry Salem of the Environmental Law Division. For your consideration today is the Executive Director's revision to the State Implementation Plan, or SIP, to demonstrate that the Bexar County Marginal Ozone Non-Attainment Area would attain the 2015 8-hour ozone national ambient air quality standard by its attainment date, but for anthropogenic emissions emanating from outside the United States in accordance with Federal Clean Air Act, Section 179B. Staff respectfully request adoption of this SIP revision. Thank you for your consideration. We are available to answer any questions.
Thank you, Mr. Foster. I have none. Commissioner Lindley?
No questions. Appreciate all the hard work that went into this.
Commissioner Janeka?
Thank you. No questions for me.
Ms. Smith, I understand that we have at least one person signed in to speak on this item.
We actually have two. The
Great.
first is Ms. Diane Rath.
Morning, Ms. Rath. Go ahead when you're ready.
Good morning, Mr. Chairman and Commissioners. I'm Diane Rath, Executive Director of the Alamo Area Council of Governments. I appear before you today to support the adoption of the 179B SIP revision that is before you. ACOG is grateful to the TCEQ staff for their efforts in drafting this SIP revision and performing photochemical modeling and other technical analyses in support of the assertion that Bexar County would attain the ozone max by 2020, but for international anthropogenic contributions. The findings in this SIP revision corroborate the EPA and TCEQ approved modeling that ACOG has conducted in the past. The modeling indicates that emission sources within Bexar County are only responsible for about 20% of its ozone, meaning that up to 80% of our ozone comes from outside our region and is out of our control. Specifically, up to 40% is foreign-borne transport. COVID-19 has really brought this issue to light recently, with much of our local activity shut down due to lockdowns and stay-home orders, and thus greatly reducing our ozone precursor emissions. Our ozone levels saw little impact. In fact, in terms of the number of moderate ozone days and higher, 2020 has had slightly more than the 2010 through 2019 average. ACOG agrees with TCEQ's conclusion that Bexar County would attain the ozone max by 2020, but for international anthropogenic contribution, and believes that TCEQ should adopt this SIP revision and submit to the EPA in light of the data contained and what we've learned from COVID-19. If the EPA approves this SIP revision, Bexar County will not be bumped up to moderate non-attainment and would avoid additional federal regulatory burdens placed on industry and the general public. I thank you for your consideration and am available if you have any questions.
Thank you, Ms. Rath. No questions for me, but I was not familiar with the analysis about the effect of COVID-19 and the reduction of emissions in San Antonio, and it's unfortunate that there hasn't been little impact, because it means that we don't have as great a control over the levers as we'd like. And I know we've put a lot of effort into help driving down emissions in Bexar County. So that was a very helpful comment. I want to thank you for that. Commissioner Lindley, any questions for Ms. Rath?
No questions. Thank you.
Commissioner Janeka?
No questions, but thank you so much for providing the input today.
Thank you, Ms. Rath. Ms. Smith, if you'll call the next interested person.
I will, and I will also note we also have a person who signed in that indicated that they didn't wish to address the commission, and their presence will be noted for the record. But our next person signed in is Mr. Cyrus Reed.
Hello again, Mr. Reed. Go ahead when you're ready.
Hey, Commissioners. This is Cyrus Reed with the Lone Star chapter of the Sierra Club, and I'll note on this item, we did submit very substantive comments, and we argued quite the opposite of what the last speaker said, which is basically, first of all, we do not feel that EPA has not even released guidance and has clearly indicated that they do not believe this approach is merited in this case, at least up to the present day. So we don't think it's legal or advisable to do this. This is not a case like El Paso, which is directly on the border. This is San Antonio, and we believe it's in the interest of the state and San Antonio citizens who breathe dirty air for ACOG and the state of Texas to work on a SIF that actually reduces ozone pollution and gets San Antonio into compliance with the Clean Air Act, and we believe it's quite possible to do that. A lot of progress has been made already. So I'm just here simply to repeat what we said in our comments, which is we do not believe you should move forward with this effort to seek a 179B, and we're pretty confident that EPA is not going to grant it. But in the meantime, we're, in our view, wasting a lot of important state resources going down this path. So we would urge you not to adopt it. I'm not sure you're going to listen to me, but I wanted to be on the record to say that.
Okay, Mr. Reed. Well, I very much listened. I appreciate the comments. It's true. I don't quite agree with them. And I read your written comments as well. I thank you for those. We need to hear those comments. Occasionally we agree, which is a great thing. But again, thanks for your input into this process. Commissioner Lindley or Commissioner Ginecca, any questions or comments for Mr. Reed?
No, appreciate the comments. I'm good. Thank you.
Likewise, I'm grateful to have that input in the discussion. I think the only way that public policy can get really fully vetted out and meted out is to have those comments from all directions. And I think on this particular rule, the supervision, we did receive a lot of comments from many different parties providing very important views. And I think that this is a complicated and another interesting issue, but one that has very, very significant importance to the state of Texas. Impacts from outside of our nation's boundaries and outside of the state's control, I think, are a paramount concern for Texas as a border state. And so I think that this is an important issue and one that I'm continuing to look at and try to familiarize myself more thoroughly with. So thank you for your input on it.
Thank you, Commissioner Ginecca. And I think we'll hear next from the Office of Public Interest Counsel.
Vic McWhorter, Public Interest Counsel. OPIC acknowledges that environmental stakeholder groups and EPA do not agree with staff's interpretation of Federal Clean Air Act Section 179B, and there's some uncertainty regarding things such as whether a 179B subsection B demonstration requires a retrospective analysis of monitoring data from all required years, or whether the required technical analysis can be done prospectively, and also whether EPA's position will change as it reviews TCEQ submittal and before EPA's draft implementation guidance becomes final. Given the uncertainty of how these questions may be resolved and the consequences for the timing of future decisions regarding the classification of Bexar County marginal non-attainment area, OPIC offers no objection to adoption of the proposed SIP provisions so that the issues in dispute can be elevated for review at EPA or other forums as necessary.
Thank you, Mr. McWhorter. I appreciate those comments. And colleagues, as we continue to reduce emissions in Bexar County, and it is a focus, we do have to acknowledge and account for these international contributions to ozone and ozone precursors. And I have no doubt that emission sources located out in the United States are affecting Texas's ability to achieve the 2015 ozone NAAQS. These types of pollutants do travel and sometimes not just across borders, but some distance. So I think that this SIP is an appropriate response under the Clean Air Act, Section 179B. I think Mr. McWhorter, identified at least one of the key issues around how to interpret that act, and agree with his analysis that we need to move this conversation forward by taking action. I want to thank staff for the good job that they've done both with the demonstration in this case and addressing the technical concerns that were raised in the comments, which is all to say that I am in favor of adopting this SIP. Commissioner Lindley, let me turn it over to you and gather your thoughts.
I'm in agreement. I think you stated very well. I don't really have anything to add in addition to that, and I'm in agreement that we should adopt what's in front of us today.
Thank you. Commissioner Ginecca?
I think my view aligns with each of yours, and I'd propose to make a motion if that's acceptable at this point.
Go ahead.
I move that we adopt the Federal Clean Air Act Section 179B demonstration state implementation plan revision for the Bexar County 2015 8-hour ozone national ambient air quality standards non-attainment area as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
The next item is our public comment session. And I believe we don't have anybody signed in, but if we could unmute the webinar for a moment and give those on the line a chance to let us know if they would like to address the commission.
Not. But that's what it's for. So if you lower it to almost nothing, if you lower the rate to almost nothing.
Ma'am, we can hear your conversation. So since no one was signed in, Ms. Smith, maybe we should go ahead and mute the line and move on with our agenda.
Okay.
I didn't want to eavesdrop on someone else's conversation.
Yeah, and we didn't seem to hear anyone. So that brings us to items 40 through 43, which are for closed session. And the commission will meet in closed session via a web conference. Would you like that to be 5 minutes, Chairman, so that people can have a chance to take a break?
Yeah, colleagues, what we'll do is we'll drop off this call and maybe take a short recess, and then we'll join the executive session. I'm not anticipating that we'll take any action in executive session. If we do, we can return to announce that. Otherwise, I'll just have our general counsel return to this meeting to gavel us out. What kind of a recess would you like? Is 5 minutes enough, Commissioner Lindley?
5 minutes is great. And before you adjourn, I do want to congratulate you, Chairman. I heard and read that you were, I guess the proper word's accepted into the American College of Environmental Lawyers. And I think that's a great achievement. And I just wanted to give you kudos and say congrats.
Well, thank you for that. Yeah, it strikes me as an honor. I have a lot of respect for many of the members of that organization that I know, and yeah, thank you for recognizing that.
Yes, and 5 minutes is great with me.
Okay, Commissioner Janeka, 5 minutes good?
Very much so. Thanks.
Okay.
Okay, then.
Go ahead.
We will. The commission will meet in closed session then via web conference beginning at about 11:58 as permitted by the Open Meetings Act and the Governor's executive order concerning the Open Meetings Act to take up and consider matters pursuant to items number 40 through 43 as posted and noticed.
The time is 11:54. We stand in recess.
The Commission met via web and teleconference for closed session from 11:58 a.m. until 1:35 p.m. on item numbers 40 and 42 as posted and noticed pursuant to Texas Government Code Section 551.074. No action was taken. This agenda stands adjourned and the time is 1:39 p.m.